Can an Indian law apply to a Hindu couple living abroad? If two Indian original spouses become foreign citizens, can they still approach the Indian court for matrimonial disputes? These fascinating questions were answered by the Supreme Court in the landmark case of Sondur Gopal versus Sondur Rajini in the year 2013. Namaskar, everyone, and welcome back to my channel. Legalese by Aditi Sahai. Today, we are discussing an important judgment that explained the concept of domicile, territorial jurisdiction, and extraterritorial application of the Hindu Marriage Act 1955. Let's first understand the facts of the case. The couples Sondur Gopal and Sondur Rajini got married in 1989 in India. After their marriage, they shifted to Sweden and even got Swedish citizenship. Later on, they moved to Mumbai for a few years and then they relocated to Australia. Eventually, disputes arose between the couple. The wife returned to India with their children and filed a petition before the family court in Mumbai seeking judicial separation and the custody of the children. The husband challenged the case, arguing that both the spouses were Swedish citizens residing in Australia. According to him, the Indian courts had no jurisdiction because they have been no longer the Indian domicile, and therefore Hindu Marriage Act will not apply. The Supreme Court had to decide the very important question: does the Hindu Marriage Act only apply to the Hindus living in India, or can also be applied to the Hindus residing abroad? The court delivered a significant ruling. It had held that the Hindu Marriage Act has an extraterritorial operation. This means that the act can apply even outside India, but only when there is a sufficient connection with India. The court explained that merely living in another country or even acquiring foreign citizenship does not automatically determine jurisdiction. The Supreme Court relied upon the doctrine of territorial nexus, holding that Indian courts can exercise jurisdiction when there is a substantial territorial connection between the parties and the India. This judgment extremely important because in today's global world, thousands of Indian families settle abroad. This case remains the landmark precedent in private international law, family law, and the law relating to domicile, making it essential reading for law students, judiciary aspirants, and anyone interested in matrimonial law. If you found this case analysis helpful, don't forget to like, share, and subscribe for more Supreme Court analysis, case analysis, and legal education content. Thank you everyone for giving so much love to my last video by liking, sharing, and commenting. Please do subscribe and hit the bell icon so that you cannot miss any legal updates coming from my side. Bye everyone and namaskar.